Lord, item 22, this matter may be adjourned, my lord. It is the other expert. Preferably may be taken on 20 minutes.
No preference. Adjournment.
Highly unlikely.
You give the
My-
name of the council.
my-
Your name
My lord.
for whom you report.
May I please?
Highly obliged.
I recommend item number 46 of supplementary.
Adjournment. You give your name, item number for whom you report.
My lord, in item 24, my lord, there is some urgency he will make mention. A date may be fixed because,
You take the
my lord, I am for the appellant.
urgency, will take it up today.
He is praying
Why
for time.
today? Adjourn today, pick another.
No, he will have to file objection in the delay condonation. That is why he will pray for time.
If possible, we did.
Item 1 for motion.
My lord may recall, the issue is inclusion of the name of mentally challenged son who's an adult in the PPO. That's an issue. So the pension department council was directed to be present.
You are not present.
Yes.
You represent the
Yes.
pension. Are you aware of the fact of the case?
Yes.
Prepared?
Because today only just for
No. Are you prepared? If not, you want
one date may
because
be
this is a
given.
little different kind of a issue and it's serious.
One date, one date may be
Issue is
given. Your Lord.
The son is mentally challenged
Yes.
and the mother is the
Mother is the petitioner. She is getting the family pension.
mother is getting family pension.
But name of the son is not in the PPO.
Ah.
So it fell from your lordship. If the name of the son is included in the PPO,
Ah.
then after the death of the mother, process it continues.
143
Yes.
that will be applicable.
Yes. That's the purpose.
Yes. One date may be given. Your Lordship.
Why?
Just today only I am appearing for the first time. Your Lordship.
What do you have to prepare?
If necessary, I will take instruction. If necessary, I will take instruction. Your Lordship. Oh, yes, then it's
The
okay. Your
law
Lordship.
is clear. Unless you deny the fact
Yes, sir.
that the son is not mentally challenged
Yes, sir.
or the mother is not getting family pension.
Yes,
Do you deny these two facts?
No.
Then otherwise, the law, the son being mentally challenged
Yes.
is dependent of the disease,
Father.
whatever his age may.
He's 41 presently.
He, as is a family member, his name should also today
Only that much. Okay.
Ah. and implication thereof will be once the mother dies,
Yes.
his name being included in the PPO,
Yes, sir.
seamlessly he'll be entitled to that
Thank you.
permanent family pension that is a dependent child.
Yes, sir.
Another 140,
Yes, 143.
140.
Yes, Your Lordship.
So do you want to obtain it?
No.
Then if you want it,
If a certificate is genuine, everything is okay, then no problem. Your Lordship.
how can we answer the if for you to
The
the if is wrong?
The prefix if.
You submit if it is wrong. This is a matter we have heard for a long time. Not that we again enjoy it.
Then it's okay. Your Lordship. I am
Because difficulty will be suppose today the mother died. There's a
yes. Problem will
and the
arise.
name is not included.
Mm.
Then what will happen
Mother
to
is
the
suffering
legal
from
right
cancer.
of this mentally
Mother
challenged?
is
Yes.
suffering from cancer.
He cannot file a writ on his own.
Yes.
He is not entitled.
And not mother is suffering from cancer.
Suppose the mother dies this year
Yes.
and you take a tax. What will happen? The PPO will die for the death of the mother.
Yes.
Name will not be there.
Yes.
How do you expect mentally challenged child to approach the court? He doesn't have a guardian.
Yes.
He doesn't have anybody. Who will come to the court on his behalf?
It's okay.
So he has to die a natural death. Survey. Because he doesn't.
Yes. It's okay.
Or if you want, you take a
It's okay, your lordship.
If you have to say something.
No,
that
your
item
lordship may
is
start, your lordship.
not mentally challenged, or the mother is not getting family pension, or they are not entitled to family pension. Please take your decision.
My lord, she desires that your lordship may pass an order. She has said so.
No, it's okay.
We are compelling her to,
No, she's saying it's okay.
that may not be voluntary.
No, it's voluntarily, I'm saying, it's okay. Lord.
Otherwise, cheating on unnecessary mess and the complication.
Yes.
Good, the cheated partner in a council for the petition. You are conflict. Or you are.
Mr. Lal is there.
For the
Number one. That's okay, number one.
MS the keep
K. Kukan,
or
government advocate, junior government.
then unique and that for the authorities and
That's one and number 2 and 3, your lordship.
Pension and Public Trust Department of the Government of Assam and MSP Bora and Council for the Defense Department. The husband of the petitioner, Guru Prasad Das, was a teacher in a
Government primary school. Yes.
Paharsoli Prathamik Vidyalaya at Walpara. For completion of his service tenure of nearly 50 years, superannuated from service. They retired from service
On 28th February 2006.
from service upon attained superannuated constantly. After retirement from service, the deceased husband of the petitioner Guru Prasad Das was paid the pensionary benefit under the Assam Pension Society. Upon death of Guru Prasad Das on 21/11/2011, a pension payment order hearing number 57299, which is undated, under the signature of the Director of Pension Plan. Family pension has been made payable to the present petitioner, being a family member of the deceased employee Guru Prasad Das. Guru Prasad Das,
You take this.
time of his death,
उसमें
left
नहीं है.
behind
Amendment is not there. You take this one. वो लोग को amendment नहीं है उनके पास पुरानी वाली. 143
two children
subgroup 3.
and his wife being the present petitioner,
Subgroup 3. Mark for it.
namely Vishwadit Das and name of the daughter. Name of the daughter.
She is married. Daughter is
She
married.
died.
Huh?
She died.
Daughter died. Daughter died.
Any idea about the name of the
Well, no idea. Absolutely.
and another daughter who in the meantime died. The son of Guru Prasad Das, Vishwadit Das, is a mentally challenged stroke retarded person since his birth. And in this respect, where is the medical certificate?
That's what medical. It is
19.
Is it page 17?
Yes, 17.
17?
Yes.
In this respect, medical certificate bearing number GTS from M
ये
of
देखो
840 from 17 dated
और पिटाई करेंगे हम।
29/9/2019 of the Chairman District Standing Medical Board Walpara is available on record as connected for page 17 to the report, wherein it is certified that Vishwajit Das is diagnosed to be a case of mental retardation with schizophrenia and since 20 since the year which was diagnosed in the year 2011 and he is receiving treatment at Walpara Hospital. In view of the
PPO,
rule 143.
yes, 43C sub rule 3, the explanation.
As per the medical document, Annexure 4, Vishwajit Das can be accepted to be a person who is suffering from a disorder or disability of mind, which has rendered him unable to earn a living even after attaining the age of 18 years, even after attaining the age of 21 years, even after attaining the age of 18 years. The entitlement to a lifetime family pension of a person suffering from a disorder or disability of mind, which had rendered him unable to earn a living even after attaining age of 18 years. It's provided under Rule 143 E of the Assam Services Pension Rule 1959 is practiced as that over
My lord, there is a provision only for the family pension, nothing else.
one by the mother under Rule 143A and an additional family pension by Vishwajit Das under 140.
The concept of additional family pension is not clear.
I think both because they are separate.
My lord, that's a matter of interpretation. I do not know. Then the stand. My lord, it's my book. I looked into it, but somehow, my lord, the clarity, my lord, is missing. That clarity is not there.
Read the provision. Because normally what happens, suppose there are 5 family members, all of them are entitled to family pension under 140A. So therefore it's one pension. And whatever the amount is given, that will be equally utilized by all the family members. If there is a question of second wife, we have decided the same with the full pension. How the second wife is to be treated. Now, this disabled person, his entitlement for family pension is not under 140. It is his own individual entitlement under 153C. how you reach out to
153. Proposal.
Yes, delete both it. Delete that.
but we'll deal it today. itself. Wait, wait.
The 143C, the very scheme says, my lord, the rule shall apply
Ah.
to pay lifetime family pension to the handicapped
Ah.
sons, daughters
So
of government servants.
Moment
Yes,
government employee.
it's other than the mother.
Government employee has a disabled children,
Yes,
irrespective of whatever pension is being paid. This is a entitlement over and above that.
over and above the mother, the wife.
Ah.
Apparently, because the entire scheme is meant for the children.
It's a separate provision.
Separate provision.
It's nowhere
Yes.
related to 140.
Yes, yes. Not subject to the other. It's independent by itself. Correct. No, I didn't look at it from that
And
perspective.
this person not existing. He is otherwise dependent. Then he will be under one enjoy the 143A of the
Yes, yes.
and once the mother dies,
Yes.
if he is entitled under any other law, he is not entitled, he is not entitled. And moreover, particularly if he is a son, he is not getting it after it.
In fact, my lord, I am enlightened now because I'm really struck the distinction between 143 capital A and 143 capital C. The 143 capital A reads, the family pension and death cum retirement gratuity to the families of government servants who suddenly disappears, leaving the families and whose whereabouts are not known shall be granted after observing the following formalities. So if something happens to employee disappears.
No, there is another provision, probably 143 is not the correct. There is another provision for family pension.
Family pension 143,
The
simpliciter.
benefit after
143, simpliciter.
simply.
Family for the purpose of rules in this section will include the following relatives of the officer. Wife in the case of a male officer. Husband in the case of a female officer. Minor sons. Unmarried dependent daughters, etc. The pension will be admissible. In the case of a widower, up to the date of his death, remarriage, whichever is earlier. In the case of a minor son, when he attains the age of 18 years. In the case of an unmarried daughter, until she attains the age of 21 years of marriage, whichever is earlier. Provided that family pension shall be allowed to continue beyond 21 years of age. Yes, my lord. So the scheme comes for family pension under 143, meant for the family. But 143C is over and above.
He is paid the deceased employee tax. There is a corresponding entitlement of the disabled tax.
Yeah.
To get pension under 140.
See.
Irrespective of whether the mother is getting or some other authority.
This is what we understand, my lord. If we look into the language of 143 simpliciter and that of 143C. C is meant for primarily for this purpose.
There may be this person may be much more over and above his daily.
Yes.
143 pension take care of the daily. And 143 daily living plus his constant treatment that we
Because the rule specifically says 143C, this rule shall apply to pay lifetime family pension to the handicapped sons, daughters of government servants.
satisfaction to be arrived whether it is
Handicapped.
handicapped or
Yes,
not that.
yes, yes, yes. So independently, my lord, of the right of the mother to get family pension on death of her husband, the mentally challenged son has his own right under 143C. Yes. I'm enlightened. I never looked at it from this perspective. It never struck me, my lord.
Oh,
I'm grateful.
but reading it just weird because this is unrelated
It's so
with
clear, so clear. The scheme is different.
anything. It is unrelated with anything.
Yes, yes. The very scheme is
Then
different.
how can you relate it with 140?
We cannot. We cannot. It's independent of itself. It doesn't say subject to 143.
Make an endeavor to.
Very well.
It have to clear over.
Very well.
Waiting for
Very well. So, my lord,
the
Sir, she has gone.
because this interpretation may have some.
Yes, yes. Yes. Yes, yes.
so better may let there be a short date so that EG can also be informed. Otherwise, he would say, though, I have not looked into it. So, yes. Could you?
Yeah, she is already gone.
You're calling the next time.
Oh, yeah.
That is Mr. Comes will price him more.
Very well. Very well.
And depending the manner he did.
Yes.
No, she has come yet. It's not available, Lordship.
Very-
I have put him for Lordship for today.
Not in
Not in that.
when you come back
Tomorrow.
or
The Lordship.
Tomorrow, if he comes, my lord, if he comes late.
Maybe
there
late, he may be
So
late.
that is why instead of
Friday?
tomorrow,
Friday.
Friday.
Lordship.
Friday, which day?
It
It could be.
an issue for discrimination has a right. As
Yes.
to the interpretation of rule 143 and 143 of the Assam Pension Act as to whether the entitlement under rule 143 is an independent entitlement over and above the provisions of 140 or 143 and 143 are to be read conjointly to give an interpretation that it is one and the same. This Friday for
Very
Friday.
well. I'll also look into it, my lord, now.
Friday hit, Friday.
Very
A copy of it already provided to MSTK. For anything that
Yes, yes.
Item 2. Made clear. This transfer petition filed by wife lordship to transfer the case of case filed by her husband at Bongaigaon lordship. On last occasion, this matter came up. There was a question query from the court lordship that whether transfer
by the way,
by the wife.
on what
Already husband is appearing in a case of DV case where the wife is residing at Dhubri.
where is the wife
Wife residing at Dhubri.
and
Dhubri.
the
Husband Bongaigaon.
husband?
Bongaigaon.
And where is the divorce?
Not divorce to lordship, that restitution of conjugal right.
Yes.
That is filed by the husband at Bongaigaon.
Okay.
In
You want a transfer of
yes, at Bongaigaon at Dhubri, he is already appearing in a DV case. Lordship. That,
Mr. A. Ahmed account for it. 24 hours. Better to take care by it. This is the next returnable date, but proceeding in ESM number 6 of 2020, the court of the
Court of Munsi, Bongaigaon.
Bongaigaon. Yes.
Item 3.
It is taken note of the submission of Mr. K. The submission of happened because taken note that between the same parties, there is a pending DTK in the court of
Judicial Magistrate, first class,
Judicial Magistrate First Class at Gwalpa,
Dhubri.
whereas the impugn proceeding has been initiated by the husband court of law.
Item 3.
Further continuation of the interim order shall be considered after hearing.
May I please, my lord? In this matter, my lord, we were the defendant in the main suit. And when our request to file WS was rejected, we came up here. And in the meantime, my lord. We came for the settlement, and there is a report by the mediator which is flagged as R, my lord, 1110, and
So yeah, both sides are agreeing to the order of the mediator. So you make it a part of a compromise.
Then there is agreement.
there is an agreement.
Understand?
Will
We make that mediation order as well as the agreement as a part of our order.
Yeah.
Make it a compromise that parties will be binding.
Pending by which, but
it
the
will
cases
be
are pending before the lordship trial court. They have to go to withdraw the cases trial court.
I don't know what is the agreement.
Yes.
I mean, they came on a settlement that they will withdraw the case, and they will our party will sell the schedule
For plot of land to
plot of land to the original plaintiff.
No, we close completely. That you both parties will be binding by the terms of the agreement.
Yes, my lord. And the
And
parties will
they-
file respective petition
Either
over
of
there.
the party doing any act in violation of the agreement shall be considered to be a violation.
We both are the witness to the agreement, my lord. There is no-
If you don't go and withdraw, it will be a violation of the code. It will be liable for contempt.
They have to withdraw, my lord.
Either you or
Yes, sir. ma'am.
as per the counterparty of the
Respondent,
form.
respondent.
Here, the IO 145 and
22, my lord.
2022 has been introduced. Agreed by the ex party order dated 24/6/2019 of the
The civil judge Nogam,
of
my
the
lord.
learned civil judge Nogam in statute 181 stroke 2021 bracket new stroke statute 18 bracket 4, whereby the petitioner defendant had been precluded from filing their written claim. During the pendency of the CIO, the matter was referred for mediation by
Mediation.
which officer? Mediation by the order dated 16/12/2020. Both the petitioner and the respondent appeared to have participated in a mediation process, resulting in a mediation order which is available as
Like the R.
like R.
Below that, my lord.
Here,
Full.
petitioner four.
Dated 11/10/23.
Mediation order dated 11/10/2026, which is available as like R. The terms of the mediation as per the order dated mediation order dated 11/10/2026 is like that. The mediation order also refers to an agreement dated 7/10/2023 between
My
the
place, my lord.
petitioner and the
7/8/20. 7/8/20. Agreement.
petition order right. Look at the petition.
So that there is an agreement, but agreement reflects 7, 8,
I know,
23.
we are, but mediation order. is
Mediation
7.
order.
It's up to the court. Court can record as per the mediation.
7/10/2023, which is also available on record, but on a permissible thing, it is noticed that the agreement is dated 7/8/2023 and not 7/10/2023. The deed of the settlement agreement between the parties is also expected as you know, as the matter had been settled by the petitioner to respond to a mediation process, resulting in a petition order dated 11/10/2020 and the deed of settlement dated 7/8/2023. We accept the settlement and compromise between the parties and make the mediation order dated 11/10/2023 as well as the settlement agreement dated 7/8/2023 part of the report. As agreed, both the parties should be signed to the terms of the mediation order and the deed of settlement dated 7/8/2023. The both signed.
Correct.
Both of them. As the mediation order and the deed of settlement is made a part of the present judicial process, it is clarified that any violation or non-compliance of any of the terms in the mediation order, as well as the deed of agreement, shall be considered to be a violation of
Right.
the meaning that here.
Hello.
Item 5.
Wait, please, Your Lordship, my lord. My lord, this is a regular first appeal, my lord.
For the first time,
First time, my lord.
are you
No, I am not the caveated. Actually, there was a delay.
sorry?
Earlier, there was a delay. So, delay. That was condoned, Your Lordship.
Condone.
Your Lordship may admit it. Only thing is that they have already been evicted.
No. No.
That becomes the title.
Yes, no, no. That
For
title,
you, it is a statement, but for us.
no, title, in the title execution case, he has already been evicted. Can use that one.
We are ready to take.
Yes,
yes,
Yes.
yes.
Mr. B. Pushi.
B?
B. Pushilal.
Pushila, the council appearing responded to admit return to all for the record of
My lord,
All right.
suit number,
for
my
the
lord.
record of the statute 21/2015 of the court of the
My lord, so far, my lord, my prayer for stay is concerned, my lord, that the statement made that has been executed. But my lord, this is the order, the case is 6/21/11.
Your Lordship,
are required to appellants have also made the prayer fee of the justice
And the,
also made a prayer for fee of the accused justice of apparent of the but it's like he took it out and talked for the content state that the judgment degree had already been executed.
no, Your
Not
Lordship, he has been evicted.
That the appellant had already been evicted, whereas the ticket asked and talked for the appellant denied
Objected.
the state state. In view of the above, the petitioner to appellant to file appropriate application. So that
in
the
fact,
dispute between the parties. appropriate
May please, Your Lordship.
Item 10 for orders.
my lord, in fact,
Your Lordship, no, what I was saying is that as regard the execution case, Your Lordship, my petition for recovery of the cost is pending. That may be stayed. Your Lordship,
We are not deciding anything. But admitting that, by your, I will,
just one submission, my lord.
we are
In
not
the,
hearing, we'll hear you when
in
you
the
file your-
IA, my lord, my prayer is for stay of the execution in the IA, my lord. So the next date is fixed for execution 21/11. my lord. Yes, my lord, yes. 2190, my lord. This is for a stay of the execution, my lord. And the case is fixed on. Yes. And the
I heard something
State.
for the as well as the cases for the issue notice return to the in the meantime, the respondent is either of
Yeah.
the the next return date, the degree date is going to
Yes.
be written.
Your lordship, may I play, your lordship? As regard, I have placed the
Obliged.
certified copy, your lordship.
Certain loose documents are produced,
Certified copy.
which is
File objection.
to be filed in an appropriate.
Obliged one, deeply obliged.
Date.
Yes.
No, your lordship, I was not objecting to this say with regard to
We are not in. You want an early hearing?
Record has to be done. Obliged.
And you file it to in the mean. Commonly bring it to the, not the loose document.
Item 10 for orders.
Even for a fellowship person. Hello. Mala, I know, man.
You will have to wait for
Mala will wait. I'll inform Mr. Thakuria. Mala,
better.
Mala, this, Mala, that's what.
Maybe the litigant is not aware.
Yes, Mala. I'll.
It is noted that if the LP that the LP task turn counsel appeared for the applicant in highest bid possible 327, but we have been informed that he is no more. In view of the above, and we also request Mr.
R. Thakuria, Mala, his name is also there. Mala, the other name in the court. Mala, Mala, sorry, M. Smith, Mala.
M. Smith, the counsel for the respondent
1 and 2, Mala.
to inform the other counsel of the applicant and also make the endeavor of performing the by
An applicant, Mala.
by a letter by a letter.
Mala, I'll inform the applicant first, and the counsel for the applicant. Mala, the applicant, Mala, I'm not sure, Mala, the address still, Mala, the applicant, Mala, the applicant, whether they are still.
Oh, whatever it
I'll make it up. Correspond number 1 and
was listed on the
Mala.
Congress part of voting. So that I need a writing letter for the director of the court
Mala.
to inform you that
Yes.
your matter is
Yes, ma'am.
remain unattended on the page.
Correspond number 1 and 2.
Respondent 1 and 2.
We take note of it later.
Mala.
Whether Mr. Thakur appears or not, he doesn't.
Mala.
And
Okay.
if informing, he doesn't.
11.
Your lordship, in this case,
If I were to take fresh step to our notice on the respond number 5.1A,
Or take fresh step.
fresh step, because our earlier steps is defect and it appears to from the official.
No, respondent number 1 and 5 have died,
Yes,
and there is an application for
Hmm.
the state application is not tax clearing.
and that's the earlier order. Yes, sir. Yes. Hmm. Yes, yes, no, I have done.
Good.
So where is your application for?
My application was filed on
In the order taken, excitement has been recorded that the Super the master for the cabinet had stated that for not five and accordingly an application for the leader had been filed. This along with the otherwise cannot proceed.
Item 12,
Such applications have been filed. This along with item 12.
May it please your lordship.
Yeah.
Lordship, the IA has been filed. Lordship, the IA has been
Even-
filed for restoration of CRP.
Sorry.
The IA has been filed for restoration of the CRP that has been dismissed for default
Correspondence or
petition.
with your client, Sunil Kumar.
Yes.
Question you are reading for restoration. Where is the order of which page is the order? It's page
no. Better no.
your name.
Jay Buragohai, appearing on behalf of G. Portal. Jay Buragohai.
E. Bora.
Buragohai.
Bora. Very time has E. Bora. The ISC 171 has been issued for forming the order dated 3/8/2021 in year IO 21/2020, whereby the petition was dismissed for non-appearance of
Lordship, yesterday we have taken first steps for the respondent number B for us. Respondent. Yes, yesterday for the
Ah, is
respondent
there-
number 1 and 2.
the office of in spite of laws and order no prescription. When
So
did
we
you
have
take
to
a
copy.
The office note dated 7/10/2023 provides that in spite of the order of the laws of court dated 2020, no fresh steps had been taken by the but MSD
Buragohai.
has found acknowledgement which indicates that the steps were taken off 7, 11, 20. You have a copy.
Yeah.
But it's the only copy. Have it with you.
Yes.
The acknowledgement produced by MS Pura company kept a record. They need to verify the acknowledgement.
Okay.
Item 13.
But with
P for a response.
whether to become the Bora company, here you can resort it instead of waiting for notification. It's almost a year now.
Yes.
That must be avoided. Conflict, right?
Right.
My pleasure. Okay. I beg apology, my lord. I cannot go through the office note, but there is a Loazima order, I think, my lord. And as per Loazima order, my lord,
Order team service to be complete in the respect of all complete under which
my lord, notices were sent through register post and as well as my lord, both 3 ways. Register post, usual process, and my lord, Dusty.
did you take the system?
Dusty we take steps, but they refused. I cannot find, I could not find.
We allow you to take a fetch the system. Date 1.
My lord, otherwise, other steps has been served, my lord. That's good. Sorry, my lord.
Very good. Take fetch the system and take along one responsible person of the society along. If you refuse this again, ask that other person to file an application. Accept the
Problem is that
problem. If you're not prepared,
Item 14.
we try to help you.
No,
You
yes,
like,
yes.
you accept, you can
no, no, she is a lady and from Borak Valley, my lord. My lord, I will take, my lord.
Turn it over. But learn to accept help also. So always
No,
develop the habit of objecting. We know you are very good in objection. That's the habit of objecting. The habit of objecting. But the easiest way for you.
Lordship, as per office noted, mark as flag A, respondent has taken this, has received a
Attorney,
complaint.
please take in.
There is the office note, it is 7/10/2060, which provides that the service report after due service on the response number 1 is to have been this up.
And develop.
15.
Lordship, already LCR has received my
Sorry.
LCR already been received my
Idea what can be done.
matter maybe fixed for hearing in its usual time.
Are you ready?
I am for responding number 1 and 2, man.
No, no, are you ready?
Lordship,
Are you ready for the hearing?
no, man, today I am.
Not ready. You are ready.
No.
The healthcare has been received. 60.
Apply. Paying for a respondent, Lordship. As per the office note, it is 7/10/2020, Lordship, the service has been completed.
Yes, Mr. It's surprise.
I am paying for respondent number 1 to 4, you know. And as per office note, Lordship, service has been completed.
So what did you want from the what did you want from the court? You said LCR is the thing.
My lord,
None of you are ready for the hearing. What order do you want?
my lord, It may be fixed for hearing on any other.
There is no requirement that specifically fixed for hearing only, that we can.
It's posted on any other.
Sorry.
On any other date.
That's the order.
Mal. Habla. Mal. Not. Habla.
Where is the applicant?
Not clear, no clear. I'm not seen it today.
Then if you for the petitioner, the council appears for respondent number
1 to 4.
1 to 4. Five
I have not received the instruction as the reply. But as regard the instruction, they have said that I have just appeared impaired in Chennai.
No, after it,
Then matter will be fixed for hearing or the matter will be fixed for hearing or no, like it fixed. If I order directs, we can file a reply.
18,
Is the lordship? I'm appearing on behalf of Mr. M.L. Pandya as he's out of station. This case is about the dismissal of the CRP number 35 of 2023. Yes, this is for default. Yes, I'm objecting, Your Honor, Your Lordship, because they have not appeared on 3 dates.
That's very bad of them.
Yes, but then
they should be forever excluded from
and because on 3 days they've taken some excuse. If you go through the, I'm just submitting because but it's not like that.
very bad. By virtue of that,
And 3 times on 3 days. Yeah.
maybe 100 times so. By virtue of that, we want to exclude them from being heard forever.
That is up to Your Lordships, Your Honor.
So
I can,
your
my thing is to tell you that
you tell
3,
me it is very good.
but it's up to Your Lordship. But the reason they have given is not a very strong reason on not appearing on 3 dates, Your Lordship.
Why did you not?
Your Lordship, because I
You
had
know,
to
what's
take
the
care.
matter about
Yes.
CRP?
The matter is about the respondent was he filed 2 divorce cases. One is at Delhi and one is
It's
at,
a divorce man.
yes, it is
You
a
are for the
divorce.
husband.
The main matter is the divorce
You are
matter.
for the husband.
No, I'm for the wife. Your
For the
Lordship.
wife.
Yes.
You are for the husband.
Yes.
Let the wife have the benefit of a hearing.
Obliged.
Uh,
I know.
Third,
As did Hayat. As Jen.
I
as
for the speaker of third amendment,
Dr. N. Borwa.
Dr. N. Grover for the particular wife. This introductory application is executed for recalling the order dated 29/5/2023, by which CRP 35/2023 was justice for non-publication. The civil petition 35 is against an order dated is reversed. They both
I get it.
have been the
But she's affluent, she's working here. A little bit of cost will teach her a lesson also, Your Honor. It's not always that the man is at fault.
for many it may be a welcome state.
I beg your pardon?
For many it may be a welcome state.
Yes, it is. It's not always that the man is at
Yeah.
fault.
Is against the You have a senior.
Actually, I'm appearing on behalf of Mr. M.L.
You may
Pandya.
appear on behalf.
Yes.
Are you representing for some senior?
No, there is no seniority. I'm only
You are
representing.
all.
Yes.
How?
Beg your pardon?
How this petition
Lordship, may I explain the case?
where is your petition on the revision?
Revision is, your Lordship, revision is something annexed here with this petition.
Where is the revision?
Yes.
Here is the petition filed as the section report.
Yes.
Which page will I write that petition?
Page number 9 to 14. Lordship,
9 to 14. Not that report.
okay. Your Lordship, give me a second. Your Lordship, in page number 12, it is about the order of FC Court dated 4 January 2023. Why the main petition? Yes, yes, this is the main petition. This is the main petition. This is the main petition. Yes. Page number 9 to 40. Here is the order. Page number.
should be. Line
240, line 240.
give the date exact date number, huh?
Like, what's the page
Yes,
number?
this is your 21, 24 page number 12.
Page number 12, yes.
Page number 12 is
Page
the
number
order,
12, order,
and
yes.
340, which is the,
340
this is the order dated.
This is the order
against-
dated
You
4th
come
January,
against this
yes,
order,
yes.
right?
Against this order. Yes, your lordship. Order dated 4th January 2023. Order dated 4th January 2023.
You read your prayer at page. What's your prayer page?
Page
Page
7. Go to page 7. Read your prayer. What is your prayer?
Honorable court, in the premises, in the premises, it is
Read it
therefore,
loudly.
in the premises, it is therefore prayed before this Honorable High Court to admit this revision petition, and after hearing all the parties, may be pleased to direct the learned subordinate court to hear the petition filed before it under section 340 CRPC.
So your prayer is
Yes.
you want your section 340
Yes.
petition to be heard.
Yes, sir, yes.
Where is the section 340? Which
Where is
Government
the-
minister.
Is there annex?
Where is the 340
I
petition?
think it is for annex along with this petition.
Why haven't you annexed it? You have to give the 340 petition, no?
We can give, file it, with.
No, what you,
I think it is for annex.
Are you sure?
Yes.
are you sure?
Sure.
It's there on
It's
page
there.
26.
26 year old.
We don't have a copy of the petition. We have not received the no copy. Yeah.
Your name.
SJ Hayat. Oh, sorry, your petitioner's name. Neha Agarwal.
Your name.
SJ Hayat, your lordship.
No, higher. How is your page maintainable? Number one. So when the petition is not maintainable, how can we directly trial court to proceed with that petition?
Your lordship isn't.
See. Go to the your page you claim it to be a petition under section 340 here. Better. Rightly, wrongly, either file that application to body trial.
Yes.
Now you want that petition should be heard. And you seek a direction from the revision. Hear that petition. We want to examine whether that petition is or maintained for the employee. Primary it is not maintained. Reason is take the care.
Okay, I can. Section 14.
And also take the Please read it for-
Allowed. When upon an application made to it in this
When
behalf,
upon an application made to notice otherwise, any court is of the opinion that exceeds the interest of justice, that an inquiry should be made into any offence referred in 195. So, your 340 application was disclosed an offence under 195 here. Now, read what 195 here.
195. IPC application. Giving or fabricating false evidence with intent to procure conviction.
So, whoever gives or fabricates false evidence, take note of the word evidence, which may result in a conviction in respect of an offense.
Yes.
By giving this false evidence, it will result in conviction of something. So this is one end. Now you come to page 26 of your revision.
That is, report petition is filed.
That paragraph is one of the state petition, that is the reverse petition filed by people. First part has stated both that reverse petition filed has been as before. So you want to say that this paragraph 21 of the reverse petition depicts an incorrect fact.
Yes, the lordship, the petition
Is it evident?
isn't.
It's not evident. If it is not evident, 195 is not evident. If 195 is not evident, 340 is not evident.
Yes.
So, you find your objection that controverting.
Yes, sir.
So not a case of tip.
Yes, this is the case with liberty to file for other relief.
No offense under, no maintainability of 340 is different. No offense under 195.
Yes, the lordship, I understand. The husband has not with, as per the information provided by the petitioner, the husband has not withdrawn.
So today you find a respondent controverted and say that that statement made it that paragraph is incorrect. Do you expect the court to drop a proceeding under
No,
section 340?
No.
Same thing has happened with them.
Yes.
If they had made a wrong statement in their divorce petition, you find your statement as controverted.
Yes.
That is the incorrect. Where is the scope of a inquiry under 340?
No.
And then offense under 195. You better close.
Yes.
You got it. Third,
MS Estate
that concept. Okay.
Dr. N. Borua.
And
Dr. N. Borua.
Borua.
Borua. BAROA. AROOAH.
That concept for the respondent Vikas Kumar Agarwal had indicated with 1121 so 26. The court of the principal guest having spoken and and the section
13,
14.
No, divorce petition under section
13(1)(1)(a).
13(1)(a)
1(a).
of the Hindu Marriage Act. Hindu
1955.
In the state proceeding, the petitioner wife filed an application under section of the CRP, wherein in paragraph 2 is stated as a reading of the amendment of the petitioner wife in the application under section 340 CRP in paragraph 2 makes it username that the grievance raised is that in paragraph 21 of the divorce petition filed by the respondent husband under section 6.2 filed by the respondent husband, some incorrect statement has been made that the divorce petition file has been dismissed as withdrawn.
Has been withdrawn.
We have already put it.
Yes.
Cannot correct.
No, no.
In other words, it has to be confused that the grievance of the petitioner wife in the application of the 340 CRP is that certain incorrect statement has been made in the divorce petition. Section 340 of the CRP provides that upon an application being made or otherwise, if any court is of the opinion that it is exceeded the interest of justice, that an inquiry should be made into any offense referred in section 195 bracket 1 bracket B of the IPC, comma, which appears to have been committed in or in relation to a proceeding in that court, comma, in respect of a document produced or given in evidence in a proceeding in that court, comma, such court may, after preliminary inquiry, if any, as it thinks necessary, do the necessary act provided in subclause 8 of section 341 of the CR. Section 340 CRPC has to be understood to be indicate that the application thereof must contain certain materials which may indicate that an offense under section 195 1B of the
IPC.
has been
Committed.
no, one. Yes, okay.
195 IPC. Giving or fabricating false evidence with intent to procure conviction of offense punishable with imprisonment for life or imprisonment is IPC. One second. Here it is 195 of the CRPC, your lordship, is prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence.
So why? Because 340 refers to clause B, subsection 1 of 195. It does not mention
IPC.
whether IPC or CRPC. But if you look at 195 IPC, there is no subsection 1. There is only one section.
Subsection 1, clause
But
B.
195 CRPC has subsection 1 and clause.
Yes.
So how do you read 340? 195 is related to IPC or it's related to CRPC?
It will be the CRP. You're right, Your Lordship.
Not IPC.
You're right, Your Lordship. I've not got the main petition here, so I
So
don't.
you have a book which
Yeah, that's all I have. Both are relevant to the same thing, but
one of the
yeah.
CRPC has been committed.
With CRPC.
Not making sense.
But both are relating to evidence, false evidence.
That
They've left out CRPC. Experience and interest is success that is very difficult. One permitted. 195 1B, 195 1B. The offenses are related here are IPC, but it actually means the CRPC. Your Lordship was right. The offenses, of course, have to be the IPC.
we are not interested to go with that.
Hmm.
Interested to
340.
ultimately correct.
195 1B is here. No mistake. Give me first. Same thing. Maintenance section 195. That is what 195 was for. Lordship, what 195(1)(b) of the CRPC is B refers to the offences in that subsection B. So 195, it is 195 subsection 1 clause B of the CRPC, which we'll be reading, and which is referring to offences of 193 to 196 of the IPC.
You be ready.
Ah.
We have to submit.
I would be very glad if you could kindly dismiss the entire thing.
That is not your submission. That is your desire.
Yes, Your Lordship.
It's your legal submission.
My submission, Your Lordship. Actually, we've not got the main petition also.
Everything is on the people here.
But both
And
speak
both of-
about
I
both.
suppose they're having a-
Yes, yes, Your Lord. Both are speaking about evidence. Both speak about evidence. So there's no evidence as such given in the as such started. Trial is not started. It was a petition. So based on the petition, they have come to against the petition, paragraph number 21 of the petition, they have come under section 340 to the trial court, family court. So 340 as of first and foremost, that entire the case only is dismissed, has been withdrawn. So is that it's actually infructuous, but since they are come against it, 340 will not lie. Come unprepared for this hearing, doing it on the spot.
Sorry.
I'm come unprepared because I'm doing it on the spot. I'm just reading it now and coming.
You also taken note. Not that we prepared last night and
It's 195.
then that it has often referred in section 191. I think coming in respect of in relationship of the section 195 of the CRP provide no court shall take of any offense
Following section.
punishable under section 195 comma 14 and 220 of the state penal code or in respect of any offense under section 471 and further in respect of any criminal commit or attempt to commit any of the offenses referred above. Second, however, it has to be understood that section 195 here provide in the event of an offense, but it was the under the aforesaid section, no court shall take from
Except upon some.
and if such offense so for except on a complaint of that court or by the officer of the court that the court may authorize in writing that or some other court to which that court is supposed. Conjoint reading of section CRPC and 195 1B CRPC makes it determined that in the event there is a disclosure of offence committed to the aforesaid section under the or a criminal conspiracy or attempt to commit conspiracy on with respect to the aforesaid offence. It would be procedure provided. It would be for the court before which that offences have been committed to form an opinion by following the procedure provided under section 340 and to send it to a magistrate or first class having jurisdiction over the matter. In other words, the conjoint reading of section 340 and 195 1 of the CRPC makes it discernible that in order to invoke provisions of section 340 read with section 195 1B, the offense alleged to have been committed must be with respect of section of the CRPC. Section 195 to 196. Section 193 to 196 of the Indian Penal Code pertains to an allegation of rendering false evidence, whereas section 200 pertains to making a false declaration and using it as for what?
Yes.
Give a broader meaning 191 days.
They have a case?
To give a broader meaning to section 195. Right.
99.
You can't say that no.
199 CRPC IPC. False statement made in declaration, which is by law receivable as evidence.
Made or subscribed by him, which declaration
Any
court of justice or
any
is
public
bound
servant.
to authorize to receive.
As evidence of any fact. It has to be evidence, Your Lordship.
evidence. Section 199 is in respect of a declaration made in any court of justice. Which is bound or authorized by law to be received as evidence at the time. One, one, one. 205 relates to
No.
false impersonation.
Not really.
For the purpose of any admission, for the purpose of making any admission of statement or something. Whereas section 06 to 2011 pertains to making fraudulent claim in respect of property to prevent its seizure or prevent its seizure or relating to any sum not due to a person under a dignity or making a false claim in a court or fraudulently obtaining a dignity or a sum not due. On the other hand, section 4.3 of the IPC pertains to forgery, whereas section 471 pertains to using a forged document or electronic record as genuine, 475 pertains to counterfeiting counterfeiting any material or device, whereas 476 pertains counterfeiting in respect of any substance or material or electronic record. In the background of the provisions of section 6, it is noticed that allegation is the section 6 of the Petitioner White is in respect of the statement made by the respondent in paragraph 21 of the application for divorce under section 21A of the reading of the statement made in paragraph 21 of the state application does not make it discernible that it is in any manner a projection of any evidence or it relates to any fraudulent attempt to property or material, or it pertains to any forgery or using of any counterfeiting device. It being so, finally, it does not appear that making that the statement in para 21 of the divorce petition, even if it is incorrect, can be considered to have been related to any of the offenses under section. If the statements in para 21 of the divorce petition are factually incorrect, it is for the respondent wife to control the same in the written state.
Respondent,
In the written state. And it cannot be understood to be an offense under any of the fourth provisions of the Indian Penal Code in order to attract the provisions of section 195(1)(b), enabling the petitioner right to invoke the provisions of section 840. From that point of view, we do not, it is not that the present civil revision petition 35 of 2023 is for a direction to the learned trial court to hear the petition under section 440 of the petition. If the petition itself is not maintainable in law, we do not find it necessary to issue a direction to the learned trial court to hear the state application. In terms of the above, the civil revision. That reason stated in the application for the photo. Okay. Civil revision to fight and it will be heard.
it's dismissed for an. Lordship, it's not dismissed. Okay? This is not dismissed.
Veto.
No, that's what I heard. Then you just gave another order. That's what I thought. Right. Okay.
We have allowed the IA restore the fear, purchase their picture.
And I got obliged. I contacted Didas. Two.
Passport for the dealer.
Next. Let's see.
I want to allow it, but without getting the
Lots
of people.
Please.
Hey, 1, 2, 3, 4, 5, so I 1, 4, and 5. Wait, your lordship. Lordship, there is 6 respondents. 6 is no ID card nor unserved notice essay. And is an important year.
In the IA.
In the address delay, Lord.
No, in the IA or in the ID.
In the I.
Appeal is yet to be admitted. And
There is
six
delay of 6 days.
6 respondents are there.
6 days.
How many are not there?
Lordship, 3 are not there. 1, 4, 5.
But they who are there?
Lordship, 1 to 5, 1, 2, 3, 4, 5 are the claimants. And they all have the same address, one address. Out of that, 3 have appeared. 1, 4, and 5. And 2 and 3, in spite of their being the same address, it's an insufficient address.
One is Mallika Sultan.
Yes,
wife of Abdul Malik.
Yes, Lord.
Third.
Mangasana, sir. He's
Yeah,
appearing.
appearing. And 2 is Sultan Sultana.
Yes, Lord.
Third one.
No, Lord,
Not served. You are not a PA.
not.
Where does Muskan Sultana reside?
Same address.
Where does she reside?
My lord, that instruction I have not, my lord. Muskan and,
No, does Muskan and
he-
Mallika, they reside in the same house? Ask Mallika.
my lord, I will take the instruction, whether married or minor, my lord, that,
Whatever.
my lord.
The mother must be knowing where the daughter is. And who is Ruxana? Another daughter.
Another time.
Ruxana is third daughter.
No.
Not sir. Farhabad is third daughter.
Third lord, he is appear.
You
My lord.
appear for
My lord,
who is that?
for this third lord.
Wife of
My lord.
Farhad.
My lord.
So who is not sir? Six is not.
Six is not third, he is the owner of the vehicle.
Owner of the vehicle. Six is separate. Your name?
F.L. Oscar, man.
Mr. F.A. Loskor enters the period for respondent number 1, Mallika Sultana, and respondent number 4, Farhabad. And respondent 5, Fariza. Notice to not be served for respondent number 2, Muskan Sultana Parveen and Sultana Parveen, who are both daughters of Abdul Malik. Whereas the respondent number 1, Mallika Sultana, who is represented by Mr. F.A. Loskor, is the wife of Abdul Malik. Mr. F.A. Loskor and counsel shall obtain information from respondent for 1, Mallika Sultana, about the correct address and residence of respondent for 2, to be informed the course of the next. What is the address?
In the meantime, lordship, person was sick, maybe permitted to take the sister.
Ambulance allowed to effect
Obliged.
Twenty-one.
Please, your lordship. May please, your lordship. As per office note dated 9/10/23, lordship, notices were issued to respond number 1 and 2, but neither edit nor answer notice has been received.
Await service report with reference to the office note dated 9/10/2023, just after 2 weeks.
23.
Hey, please, your lordship. My lord, I am appealing for the respondent number, respondent. I beg to pray that, I want to.
Mr. D. K. Kotoki, Land Council, has entered appearance on behalf of respondent number, sole respondent.
I want to file my affidavit in opposition in the.
And please for 2 weeks time, 3 weeks time to file the affidavit, pray along, just after 3 weeks.
24.
Mr. L.R. Mozumdar, present for the appellate.
Please, your lordship. My lord, here in this case, there is a.
And in the morning, you said something, you know, what?
I entered appearance for the full respondent lordship.
Ah.
I will be allowed to file my objection on the IA lordship.
My lord, the execution case is going on. He is proceeding with the execution. So
It's a delay
Mr. Chakraborty,
Chakraborty, S.
you are S.
Yeah.
Mr. S. Chakraborty, Land Council enters appearance on behalf of the
So,
respondent and please for how much time?
2 weeks time.
2 weeks time to file the affidavit till the next return were laid. For the proceeding in the execution resultant execution case be not carried forward.
Delay.
Delay
is there, Lord.
Understand, by the time we decide, suppose everything is over and we condone the delay, then what will happen? Further consideration would be a continuation of the interim order would be made on the next returnable date. Only till the next date.
There is separate IA also. For 8 days.
No, but first we have to condone the delay. There he will raise an objection. Suppose we dismiss the IA, it will be in there only. And if we allow the IA, then we'll hear stay on its own merit. Now it is only a
Only as an interim measure.
for convenience,
Much of-
not on merit.
25 and 26.
Mr. Biswas, Chauhan prays for some time to file objection. Where is Mr. Chauhan?
They have filed their objection.
S. Chauhan, he had filed the objection.
Yes.
You are appearing. It's S. Chauhan.
They have filed their objection.
Today, IA is for interim
We
order.
had filed because there is a violation of the order that was passed by this honorable court while admitting the appeal of
Just,
the
yep,
second.
under order 13, oh, injunction violation.
The second appeal filed by them is against a concurrent finding in our favor. We were the plaintiff.
No, and which order had been violated?
Violated, your lordship will find in our IA that we have filed. Your lordship. The order
Is there any,
page 11, your
is there any interim order in the IA? No.
We have annexed that particular order at page 17 of the IA,
17.
the operative part. The last portion. The nature and character of the.
After this order, again it has been violated.
After this order, what they are doing, in spite of they are carrying on, means they admit in their objective that we are only carrying out cultivation. We are not changing the nature and character of the soup. But they are digging the soup while cultivating. Your lordship is where the digging, etc., is going on. On the guise of cultivation, they are changing the nature and character of it. They are erecting thatched house over the soup on the guise that they are protecting the cultivation they are carrying out. In spite of the fact that counterclaim.
Hey, just a minute. It's a agricultural land or
It is an agricultural.
agricultural land?
What has happened is their counterclaim has also been dismissed.
Just a minute. CPC consent. So what order do you expect? What kind of an interim order you expect now?
Means not any cultivation gift, because what has happened is their counter.
We understand. Now, what kind of order you expect now?
A restraint order that they should not excessive digging of the land and.
Now, who will verify what is
That is
excessive
true.
digging, what is less
They
excessive
are-
digging?
They admit that they are only
No, that will again add to the confusion.
because.
Suggest some order which will be concrete enough to be implemented.
Enforced, that is,
Ah.
and I know that is a agricultural land,
Hmm.
but the thing is a person
One,
who has
no, Who is the plaintiff?
I am the
You are plaintiff. What is the claim of the plaintiff?
over the possession over the suit land because he was
No, you are right title interest over the suit land. That is your case.
and we
Suit has been declared in your favor,
it was decreed in their favor. The appeal was also
dismissed.
dismissed.
Now,
Their counterclaim was rejected.
now they are in second appeal.
They are in second appeal.
And in
against
second
the-
appeal, how they are in possession to undertake cultivation?
Because they were a permissive occupier at one point of time.
Permissive occupier, their right had been. I think there is a provision somewhere where the proceeds of the act there's a restraint order from disbursing and utilizing the proceeds of this act
Yes.
to be kept with some authority.
Section 80.
I think one provision is there somewhere. Please check up in the CPC.
Yes.
Think about it, that let them proceed, let them cultivate. Whatever the proceeds, they cannot
They
get
cannot
the,
appropriate the entire-
they cannot use the benefit of that proceed. It will be deposited somewhere.
Yes.
And ultimately, when you decide, whoever wins will get the money.
a separate person may be, a receiver
Ah.
may be appointed.
Or else they are at liberty not to cultivate.
That is the only.
Just find out which provision it is.
Just, give me-
I think in some law that provision is there somewhere.
It would be.
Not attachment. It is not attachment. Or it's a part of attachment only. Just check out.
What if give me 5 minutes and just.
Just examine whether orders of that nature can be passed.
37.
Yes.
My lord, substitution petition will-
IA for substitution.
Yes. this one
You
was-
are objecting.
Lordship, I am not appearing on behalf of responsible person.
Definitely you cannot. You come in only when they are substituted.
My lord, we have filed a wakalatnama for other responsible.
And very well. Heard Mr. R.S. Chauhan, and is it on time?
Yes, ma'am. My lord, not on time, my lord, my lord, I am newly engaged counsel. Can you see paragraph 4, ma'am?
Hmm.
Paragraph 4, minute, page 8.
You want some respondent had died.
Yes, my lord, 1 and.
You are for the petitioner.
Yes, ma'am.
You want to substitute their legal heirs. When the person died?
My lord,
When did the person die?
my lord, 1 in 2016, my lord, before filing of this case.
No, it has to be before.
Yes. No, my
You,
lord. Before filing.
you
the-
cannot file substitution before the man dies.
CRP. CRP number 260, my lord, before filing this. So, my lord, newly engaged counsel, I am newly engaged counsel, my lord.
Why don't you file an application for amendment of the CRP?
My lord, since.
No, just substitution is somebody is already in.
Yes.
Okay, he dies. You substitute the legal heirs. But here is a case, the man died before filing of the CRP. So you could not have filed a CRP against a dead man.
Yes.
So the man is not yet in. He is not in. Once he is not in, there is no substitution.
My lord,
A remedy for you will be to make an amendment of the CRP of the cause title, that instead of the dead man, delete it, and the legal heirs, you make them a respondent. I think that's the law.
Why not earlier council, why not notified?
I don't know.
I'm newly
I don't know any earlier council, new council. I know only the litigant. That is the law. Because a revision is not maintainable against a dead man. Had you known the fact about a person not being alive, you would have filed a revision against the legal heirs of that man,
Yes.
making them a respondent straight away.
My lord, but in case of my lord, respondent 1-7, who died subsequently. During the
So
prosecution.
you separate the two.
Yes.
Man who died later,
Yes.
we'll consider it separately. Man who died earlier will be considered separately under two different laws.
In respect of respondent, my lord, 1-7. is being-
1/7 he died later.
Yes, ma'am.
On which day he died?
One minute.
Then, yeah,
1/7, on which date did he die?
2018.
1/7, who is 1/7? 1/7 in the CRPC.
Yes, madam, CRP.
1/7.
Sattavishwas.
Satta? No, CRP, okay, 1/7, right. 1/7. Satta Biswas. Satta Biswas died. When did Satta Biswas die?
2018, madam.
Huh?
In 2018, madam.
Then the revision has abated against Sattva Biswas.
My lord,
You having not substituted, I think, what's the limitation? 3 months.
Yes, madam. Technically.
I think it's 3 months.
Yes, madam.
So you having not substituted within 3 months,
Yes.
revision has abated against Satta Biswas.
That's
So now we have to file an application for setting aside abatement.
Yes.
And another application for condoning the delay in filing the application for abatement and application for substitution.
That is the.
Have you filed it?
No, madam.
Please file it.
Since my lord,
Otherwise, we cannot entertain this petition.
yes,
Because rightly or had you filed it within 3 months,
yes.
we would not have issued notice. Straight away, he would have been substituted. But once 3 months is over, the suit has abated. I mean the petition. And the legal heirs, a right had accrued to them, right of abatement. So to overcome that, you will have to set aside notice and hear them also. What kind of objection?
Yes. File only.
Ultimately, it will happen, but
No,
process
my
is longer.
lord, reason is that, my lord, I'm newly in this council only.
Sorry.
I'm
You-
newly in
you-
this
oh,
council.
you
Yes,
do
my
it?
lord, so only-
Mr. R.S. Chavan and counsel for the applicant praised for an adjournment for doing the needful as regards filing of appropriate application for for setting aside the abatement as well as for condoning the delay in filing the application for substitution.
only.
And the other one,
Other than- yes.
you think about it. I think you can straight away amend the CRP.
Obliged.
28.
Yes, Madam Chakraborty.
In this case, my lord, I am the appellant, my lord. And they have filed one petition, IANC number 2729/2023 for fixing the matter for early hearing.
Start. Petition allowed. Start the hearing.
Yes, my lord. So, my lord, in this case, my lord, I filed this appeal against the impugned judgment dated 18/6/2015, passed in A number 166/2012. Here, the Planet RCT decided the matter against the railway by issuing direction to make payment of the 4 lakh.
This is under the Railway Claims Tribunal.
Yes, my lord.
Um, 4 lakhs. And what was their claim?
They are claiming that they claim more than that, but the RCT decided 4 lakhs.
No, no. What is their claim? For what purpose
For
that claim
untoward
is made?
incident, the passenger was traveling by a train and suddenly fallen down from the train, and it is they have taken this untoward incident, and they claim the compensation from the RCT, and RCT allowed their compensation. The direction.
And union is against that.
against
On
the
what
rate.
ground?
So, my lord, in this we have.
No, on what ground you have filed this appeal?
I have filed this appeal. The respondent is not a bona fide passenger. On inquiry, they have found that there is a outdated ticket, which is not the ticket of the same date. So.
So that it's a fraudulent ticket. That
Yes.
means.
fraudulent
After that date, somebody procured some fraudulent ticket and said that I was a bona fide passenger.
If
That is your case.
Moreover,
When did you detect this fraud?
yes, my lord, there's did you file my affidavit,
No. Did you take this stand before the tribunal?
filing written statement, my lord,
Ah,
that they have not. And
no,
and
that the
our-
ticket is a fraudulent ticket.
Yes.
Did you take that stand in your written statement?
Yes, my lord. In a written statement also, in this, here also I
No,
filed all
no.
the inquiry.
Here you
report.
have taken, I know. Where is your stand in the written statement?
Written statement in the LCR, my lord.
If you are not prepared, let us not waste any time. We'll fix some day. Are you prepared?
My lord, actually, written statement is not with me, my lord.
Sorry.
Written statement not, I'm only judgment, other the inquiry report, investigation report, everything is with me. And I filed before the honorable
No,
court.
no. Do you have the materials to answer the questions?
Yes, my lord. There is nothing, my lord. Only one ground, my lord. Their RCT failed to. look
Then
into-
show your statement in a written statement that he was traveling with a fraudulent ticket.
Yes, my lord. My lord, in my ground, my lord.
Not ground. Ground is your own statement,
Yes, my-
material.
yes, but during the outdated, during the inquest, 2 outdated ticket. By PNR
During the inquest is done on a dead body.
Yes, my lord. From the dead bodies, they have received 2 tickets, which was not ticket of the
Acha,
relevant
this
date.
person who died was carrying 2 tickets in his pocket,
Yes, my lord.
and those tickets were outdated.
Outdated.
Who had issued those 2 tickets?
This is the railway, he obtained from the railway counter earlier. I don't know, this is not a big, because.
No. On who had issued, on which date the tickets were issued? Suppose this
Yes.
man went to the railway counter, bona fide passenger, pays for the ticket.
Yes.
Railway gives him an outdated ticket. Any passenger who buys a ticket never reads each and every word of a ticket. Pay the money, buy the ticket, get into the train and travel.
Yes.
Suppose the railway authorities had given him an outdated ticket, how do you know?
No, I can purchase ticket any day. But
Your,
traveling in
how do you
outdated-
know that your officials have not conducted a fraud in giving him an outdated ticket?
Yes.
Maybe the clerk had pocketed the money and gave some outdated ticket lying with him.
No, what-
Did you conduct any inquiry on that?
Yes, my lord. I already submitted my inquiry report here, my lord, by filing a repeat, my lord.
Anyway, before that, where is your stand in the written statement? Please show it.
Written statement is not with me, my lord. Yeah.
Before a hearing starts, there is also a requirement to go through the records also. It's not that court has to look into everything and you will only make your statements.
My lord, at page 26, my lord, written statement.
Please,
I'll write
please,
it.
please read the statement where you have said that the man was traveling with a fraudulent ticket.
My lord, in para 3, that with regard to the statement made in the paragraph 6 of the applicant stated that on 14/8/2012, the victim late Sanjay Kumar Roy fell down from the Trivandrum Express train at Gola, Karachi village at KM number 645/16-18 while the victim with the two passengers were traveling from Palasa to Guwahati railway station with a valid journey ticket number B so dated 14/8/2012. As a result, the victim.
When did the accident take place?
14/8/2012.
Same date.
Same day.
Okay, huh.
As per their statement, they have purchased
No,
the
no.
ticket on the same day.
Madam Chakravarti, please cooperate with the court. We are not asking their statement. We are asking where is your
Written statement.
written statement that he was traveling with a fraud ticket.
No, I am going to.
Don't go everything. Please point out to where that statement you have
Yes,
made.
madam. As a result, the
Please
victim
don't read it again. We are not interested.
valid journey ticket number B so and so.
I don't. Next day.
29 and 30.
What to do? We can't waste our time.
So, madam, date may
Please.
fix, my lord.
We'll hear you whenever you get time. We gave you the opportunity today. We are asking you the most rudimentary and basic question. Did you take the stand in your written statement that he was traveling with fraudulent ticket? And if yes, where? And you were reading the complaint petition, you were not referring to your,
Reading complaint petition, my lord.
in his written in your written statement, where is that line? That he is traveling with a fraudulent ticket?
My lord, in my para T, it is mentioned, my lord.
Please read that
Yes,
line.
my lord. It is pertinent to mention here that from the final report CD dated 4/12/2012 of the station house officer, Government Railway Police Palasa, it testified that during inquest, 2 outdated tickets by train number.
Yeah,
24
yeah,
found
yeah. Just
in the
hand over
possession
the,
of the disease.
please hand over the records. And did you exhibit the 2 tickets? Did you exhibit the 2 outdated tickets?
No, madam.
Then? Are you not required to examine whether the tickets are outdated or not? If you have not brought it on record, how can you examine? Railway is a huge organization. You must be having some budget of 400,000 crores or something. One man has died, some 4 lakhs is given compensation. Why don't you pay it? At least the family will survive. And you're going for all this.
Because if it is proved that is an unfortunate incident, he is a bona fide passenger.
Understand, technically you are right. But is there any material to show that this ticket was not issued by the railway authorities? You have said the ticket was purchased on that 12/8 something, some date. Accident took place on that day. If he had purchased the ticket on the same day from your counter, who is liable? Railway is liable to giving an outdated ticket. The passenger is not liable. So how can you deny compensation on that ground? And mind you, once cost was imposed on the railways for filing appeal against a claim, when the cost of litigation was found to be 10 times than the value of the claim compensation. Your officers basically have a habit of filing routine appeals.
So, my lord, an opportunity may be granted, my lord. I have.
Find out.
And I find
But
out.
if you can establish that this man
Yes.
had procured a ticket by fraudulent means
Yes.
and then traveling, then onus will be on him.
So an opportunity may be granted, my lord. I'll find out. Though it was not.
And this is the appeal of which year?
2015.
15. Death of 2012. 11 years have gone by.
My lord, the judgment was passed in the year 2015 by RCT.
Understand.
Now-
Did you get any money? Nothing.
No, nothing.
Nothing. See the state of the family. And that too on a ground which is, I don't know whether it is.
My apart from this bona fide passenger or not, my lord, I have taken.
No, Madam Chakraborty, technically you are all very right. Bona fide passenger. I know it's a good term. It's there in the law also. But the burden is on the railways to prove that he is not a bona fide passenger. It's not on him.
Correct.
Because the objection of bona fide passenger is taken by the railways. Here 106 Evidence Act will be applicable. Burden will shift on the railways. You will have to prove he is not bona fide. Why he is not bona fide? He was carrying an outdated ticket. If your stand is he purchased the ticket on the day of the occurrence, then it is the further burden on you how the ticket happened to be outdated. That means your counters are selling outdated tickets. One possibility. Two possibility, your clerk is unscrupulous. He pocketed the train fare and from somewhere else gave him one outdated ticket. Go and travel. Did you make an inquiry on your clerk? How an outdated ticket was purchased on the same day?
Yes.
I don't think you had done that inquiry.
My lord, I have to obtain instruction.
This must be a good case for dismissal, I think.
No, my lord, I say one last opportunity may be granted. I obtain instruction.
Why one?
He really failed to prove.
No,
Then
we'll,
go
Madam
ahead.
Chakraborty will give you more than one opportunity.
Yeah.
Don't worry, but you have to prove it. It's
Yes,
your,
my lord,
it's
I have understood. My
your
lord.
case.
Yeah, I have to prove.
Especially we are interested in one line. You said he purchased the ticket on the day of the accident. So if he had purchased the ticket from some tout somewhere, you tell us through evidence that he had purchased the ticket from some outside source. If he had purchased the ticket from, but that evidence has to be brought so that he can controvert it.
Yeah.
If he had purchased the ticket from the railway counter, why one outdated ticket was sold to him?
In these two tickets from the pocket of the deceased.
Definitely, he'll carry the ticket in his pocket. He's not expected to carry it anywhere else.
So,
The railways have instituted this appeal against the order of the Railway Claims Tribunal awarding 4 lakhs of compensation to the deceased in respect of the death caused to the deceased on the ground that 2 tickets during the inquest, 2 tickets were found in the pocket of the deceased, which according to the railways were outdated tickets. It is also the admitted position of the railways that the tickets were procured by the deceased on what date? The 2012?
On 20,
Some 2012 you said.
12. On 14/8/2012.
On 14/8/2012, which is the date of the accident itself. Taking the plea that the tickets were outdated, the railways seek to contend that the petitioner was what term? Bona fide passenger.
Petitioner is not a, claimant was not a bona fide passenger.
That the deceased was not a bona fide passenger. A further question would remain that if the ticket was procured on the date of the death itself, and the tickets according to the railways were outdated, who had provided the deceased with the outdated tickets? Or the railways may indicate to the court the relevant materials that may be available for its examination on the aforesaid aspect.
Twenty-nine and 30.
One date may be picked. One date may be placed.
No, then this thing heard in part, listen to it.
Of like case.
May it please the lordship.
Lordship, I am praying for certain accommodation today. This case is led by Mr. Arvind. He is undergoing certain medical.
Adjournment on the prayer, Mr. R. Sharma, learning counsel for the.
My lord, actually, Mr. Arvind Pupin is appearing for OP number 8, my lord. He is the, my lord, pro forma OP, my lord. Actually, my lord, the order was passed against the OP number 8, my lord. On the behalf of my lord, OP number 127, my lord. But it is affecting the petition, my lord. Actually, my lord.
No. Mr. Gaur, are you objecting to the adjournment?
My lord, my lord, that I'm not seeking any order against the OP number 8.
Whose appeal? Your appeal.
No, my lord, appeal is my appeal filed by the OP number 8, my lord.
He is now he is filing IA for impeachment in the second.
No, I'm not, my lord, I'm not interested in, my lord, just, my lord.
Adjourned to be listed again on when do you want?
My lord, date is 28.
20th November.
Oblige.
31.
Yes, Mr. Mullah. Again, railway claim. This time you did not get the money. This time you did not get the money.
No, we have not got.
Dismissed. Claim is dismissed.
No, railway tribunal has awarded in our favor.
Check tribunal in your favor.
Yes.
You are for the respondent now.
Now we are for the respondent.
Then
Railway has filed the-
you should be this side. I thought you were the appellant now. Yes, Mr. Goswami.
My lord,
IA for what purpose?
my lord, I have not, he has filed the IA. My lord, IA, we have, in IA, my lord, he is the applicant, my lord.
IA for what purpose?
For expeditious hearing, my lord, because long pending matter.
Same answer. Start the hearing.
My lord, actually, today I am not prepared. My lord, tomorrow, my lord, day after tomorrow, my lord, if possible. My lord.
I heard Mr. Diamullah regarding the petitioner. The applicant seeks for an early hearing of the connecting MFA 101/2020-2016. We proposed the appellant to conduct a hearing today itself, but Mr. G. Goswami, learned counsel appellant, states that he is unprepared and accordingly seeks another date for adjournment. List on so and so of MFA, so for its final consideration. I allowed.
Item 32.
Take a date whenever you want. Yes.
Please, your lordship. Lordship, this is an area for correction of cost title of the respondent.
In
Name has been amended.
in which page? Where do you want the corrections?
Page 5.
Page 5.
There are two.
And in proper in the cost title at page 3 of the petition. And the name respondent. This petition is pending.
Pending.
CRP is pending.
There is pending. There was a mistake in the name.
No, we allow it. It's a trivial mistake. Heard your name, madam?
SS.
SS Bora, learned counsel for the applicant, then also heard Mr. R. Day, learned counsel for the respondent in the interlocutory application. By this interlocutory application, a correction is sought to be made in the name of the respondent in the cost title of the accompanying CRP IO 215/2023 to the effect that instead of Jalaluddin Loskor, the respondent be read as Jamaluddin Loskor. Considering the nature of the correction sought, the petition is allowed. The name of the respondent stands corrected as Jamaluddin Loskor.
No,
Jalal.
Jalaluddin.
In the case, it is Jamaluddin. He ought to have been, it would ought to have been Jalaluddin.
As Jalaluddin Loskor. Registry to incorporate necessary correction in the cost title of CRP so and so, and also a correction in the CIS system. I allowed as indicated.
34.
Anything more? No. Yes.
In this case, my lord, we require 2 weeks time to file our objection against these intellectual
Mr. N.C. Das, learns in the council for the respondent in the IS 64.
2 weeks time.
2 weeks time to file an affidavit, pray allowed, just after 2 weeks. 35. Yes, Mr. Bora.
May I please, your lord, my lord,
IA has been filed praying for condoning the delay of 151 days in preparing the revision.
Notice served. You are appearing. Are you objecting? I heard Mr. D.P. Bora, Land Counsel for the applicant, also heard Mr.
G. Bhardwaj.
G. Bhardwaj, Land Counsel for the, how many respondents? For the respondent. The interlocutory application is instituted under Section 5 of the Limitation Act for condoning the delay of 143 days in preferring the accompanying CRP 11500/2023 bracket filing number. Full stop. Mr. G. Bharadwaj does not object to the delay being condoned. In view of such statement, the delay of 143 days in preferring CRP filing number stands condoned. I allowed. Registry directed to register the civil revision petition as per.
The copy of the
law.
revision petition it is upon.
If you want, it will help you.
Yes, madam.
36.
Otherwise, suppose we don't issue notice.
Yes.
Suppose we don't issue notice, then what will happen? Suppose after hearing Mr. Bora, I dismiss it straight away. Then why do you need a copy?
Yeah.
Since I'm already appearing.
Understand? By taking a copy, you are obliterating the possibility of
Admitting the.
dismissing the petition on straight away. If you want, take a copy. We don't mind. Yes.
Your Lordship, my senior is on his legs in other
Finding.
exam.
37.
बोर्ड से नहीं की को लेगा नहीं
File an IA. We want to file our response. Lordship, may grant us 2 weeks time.
Mr. B. Chakravorty, Land Counsel for the respondents in the IA prays for
2 weeks.
2 weeks time to file an objection. Pray aloud, list after 2 weeks. Sorry.
It's a date. Arbitration, my arbitration proceeding has been stayed, madam.
List on Swain, prayed for. Yes, next IA for what purpose?
Your Lordship, the IA has been filed to bring on record the alternate address of the
Alternative address of
the respondent. The one respondent.
Abhijit Oza.
Yes, your Lord. Saha.
Heard Mr.
GR
G. Mojumdar, I think.
GR
GR Dotto, Land Counsel for the applicant. This interlocutory application is instituted for bringing on record an alternative address of the respondent in CRP IO 240/2023. Considering the nature of the issue raised, we allowed the petitioner to also incorporate the alternative address of the respondent. The cause title of the CRP so-and-so be accordingly corrected by the registry, and also the CIS system be updated. I allowed as indicated. Anything more? The alternative address is Hitu Code Corridor. Which one is the alternative?
Paragraph 5.
The alternative address is as extracted, huh? Paragraph 5. You given the complete address.
Complete.
Okay, Hitu Digibo.
39.
Yes, 39. What is it?
I is for condonation of delay.
Delay of how many days?
10 days.
10 days. Are we required to issue notice, or we can condone it straight away? Are we required to issue notice, hear the respondent, and then condone? or we can use our discretion and condone it. What is the law? Notice. But Mr. Arjun, issue notice returnable 6 weeks, extra copy 3 days, steps by registered post 3 days.
40.
I think the court has the discretion of a smaller delay. This next item, item 40. None appears for the petitioner. List again.
41.
You bring the proposition, then I can condone it. One proposition is there. When the delay is a negligible delay, only a technical delay, court has the discretion to condone it even without issuing notice or hearing the other side. Or else we'll have to issue notice. We have to go by the technicality. Which one you want? It'll be faster for you if I condone it. But there is a proposition. I don't know the prayer of Mr. Arjun. To be listed again next week. Find out. I think one proposition is there. Yes, Mr. Roychari, I think one proposition is there. A limited discretion is vested in the court even without hearing the other side.
In 60s, there is that.
I think
16.
Only when it says very small or negligible delay.
For ends of justice.
If I remember correctly,
Your Lordship is absolutely correct, around 64 to 64, but I'm not.
Something there.
Accurately.
Try to find out. Because I have to quote that judgment if I condone it without notice. Same. 40. No, this is 41. Huh? How many days?
Only 3 days after.
Oh, it will Nikki. Oh, yes. This one adjourn next week. Try to find out that proposition.
Okay.
42.
I'm appealing for the petitioner. My friend has filed to IA for rectification of the interim order of stay.
IA.
IA has been filed.
IA 936.
936, and my lord, another IA is 1001. One for rectification, another for my lord injunction against the petitioner. My lord, rectification, the lord, they wanted a police verification. Report was submitted that their allegation was that we were constructing in pursuance to stay order. Police report says that there was no construction. And the main case is this, my lord. I am a defendant in a suit. I have filed a counterclaim. I claim a right title interest over the and position over the suit land on the basis of a registered sale deed. And their case is by filing a claim that the sale deed is bad and the mutation order has to be cancelled.
They have challenged the sale deed.
Sale deed.
And they challenge the sale deed, and in counterclaim, you say that on the basis of that same sale deed.
Ultimately, my lord, they filed written statement in counterclaim. We filed written statement in the suit. Then at the stage of evidence, they did not proceed it. So the suit was dismissed for default, and the counterclaim proceeded to ex parte. And counterclaim was decreed. Then in a composite order, my lord, the setting aside of the dismissal order, then setting aside of the my lord
ex parte
counterclaim order and the limitation order, all were discussed and it was allowed in their favor.
Where? In the petition under Order 9, Rule 13.
Order 9, Rule 13 and Order 9, Rule 9.
Their case was allowed.
And there was a delay of more than 1 year, but only allegation in the delay was there that the advocate, by name they have stated, that advocate said that the suit is proceeding in the right way, but he has never appeared before the court, and the suit was dismissed for default. They didn't have any knowledge, and on that basis, neither the advocate was examined.
No, now who filed the CRP?
I filed the against that order.
Against the order of Order 9, Rule 13.
13 plus
the Order 9, Rule 9. Against that, you have filed a CRP.
And the subsequent, the suit was stayed.
And now he has filed an IA for
vacating the stay order and an injunction against me not to construct it in the suit property. So there was an order from this court for a police verification. And then the police verification.
Police verification of what?
My lord, whether there was a construction going on my farm. That was order dated 24/23 in IA 1001/23.
Let us say here that main order under Order 9 Rule 13, I think instead of
Yes, my lord. Other day, I think.
unnecessary,
Your lordship may just fix the
Single
date.
issue, my lord.
unnecessary, the whole thing will be delayed for both of you.
Absolutely.
I'll make an inquiry, appoint, commissioner, do this, do that.
Yeah, we will-
And one of you will go and challenge the report of the commissioner, he is wrong.
Well, I admit to my.
So if the setting aside of the expertise is good, the suit will be heard on its own merit. And if it is not good, we dismiss it.
TRP may be heard.
When do you want? Today?
Well, on 16th.
Oh, we are ready, don't worry.
My lord, your lordship has a vast experience. My lord, I am very much a limited person.
No, it's not an experience.
My lord, I am a
Mr.
junior counsel,
Rochadri,
my lord.
we also gain experience every day. In every petition, we are gaining experience.
It's a learning process in less manner.
My lord, on
No one knows everything in this profession.
my lord, on 16th.
We can only try our best, that's all.
My lord,
Sometimes you are wrong, sometimes you are
for
right.
such a long period, my lord, at
Okay,
least we have got a lot of judgment from this court, my lord. That much we have to say.
So when do you want?
16th.
Sorry? As prayed for by both by Mr. P.K. Roger and also petitioner as well as by Mr. S. Chamorial and counsel for the respondent, list on so and so, and endeavor shall be made to give a final consideration to the issues raised in CRP 291/2022.
Interim order to continue.
Interim order to continue till then.
43.
Obliged.
Transfer.
If with your lordship. I prayed 3 weeks time to file reply, lordship. This is a transfer petition, lordship.
You're for the husband.
Yes, lordship.
Ms. P. Bacharji, land counsel, responded for 3 weeks time to file a reply to the reply. Pray a lot, list after 3 weeks.
Obliged.
Interim to continue till then. 44, yes, 44 was it? What is it?
Your lordship. My senior counsel, namely.
Well, let him take rest. What is the matter about?
Certainly unwell.
No, we wish his early recovery, but what is the matter about?
There is.
My lord, we are the plaintiff, my lord.
Okay, if he is unwell, what to do? It's stated that Mr. M.J. Kadir is unwell today and accordingly adjournment, prayer for adjournment allowed, list on so and so, interim to continue till then.
My lord, that interim is there, lord, because if that interim is continuing, my lord, then the main facts of the title.
Then you have to send a doctor, get Mr. Kadir recovered from his illness and bring him to the court. We'll hear you. A lawyer is unwell. So tomorrow, if you are unwell, if I pass a order, will you like it?
I love.
Same is it, Mr. Kadir also. Take an early date if you want.
Item 45.
Yes, Madam R.A. Chaudhary, due to paucity of time could not be taken up, interim order extended, this interim order extended. Being agreed by the order and just presiding of the special tribunal. What is the special tribunal?
Land grabbing case.
That land grabbing.
Land grabbing.
Ready? Are you ready? You have to file counter. Your name, please.
P. Chakraborty.
P. Chakraborty. Mr. P. Chakraborty, learned counsel for how many respondents?
There are four respondents, Lordship. He is appearing for one and
For respondent 2, praise for how much time?
2.
2 weeks.
2 weeks. 2 weeks time to file an objection. Pray aloud. List after 2 weeks. 1 and 2. 2 weeks. List after 2 weeks. Interim order passed earlier shall continue.
Did you get something?
This is a very famous case.
Didn't see. What is the issue regarding registered document?
Regarding registered issue of the judgment law.
No. We want a proposition that if a sale deed is registered, the executors need not again prove it.
Yes, Lord.
Because a registered deed is admissible in evidence by virtue of being registered.
That law has been let down in para.
Now which line?
Uh,
Which particular?
Para 13.
13.
Last page.
Yes. But this is good enough for us.
There are many judges.
No, this is good enough. It's very clear and explicit.
Very clear. Because burden shifted.
Because my perception was that only. Registered document is not required to be.
That is the correct.
But should I deliver in his absence or I give him one opportunity? He said he'll go to Para.
Has no objection. If the
But still,
matter is remanded. Yesterday he
no,
has
understand,
submitted.
but still, will it be
I leave it to your lord.
in his absence?
No, I leave it to your lord.
We are fully convinced with the matter on 2 issues. One, plaintiff claim is, I have right title and interest over Patta number 25, Dag number 20. His claim is, I have right title interest over government land covered by Dag number 20. Court never went into the question, which is the disputed property.
Yes, sir.
Whether the government land is the disputed property or the Patta land is the disputed property. Until and unless you first take a call, which is the disputed property, how can you determine the respective right? You have established you are the owner of a Patta land, he has established I am the owner of a government land. So if I don't know which land is involved in the dispute, how can I decide?
The proposed force.
So that way, the one issue ought to have been framed on that issue based on paragraph 4 of the plaint and paragraph 4 of the written statement. Number 1. Number 2, the registered exhibit 1 was rejected by referring to section 67. In our view, section 67 evidence is not applicable in this case because per se, as per record, it is a registered document that has been produced where there is a presumption of its validity. So these are the only 2 issues.
Yes, lost. The best course on the courts below would have been lordship to frame a issue whether the Schedule B property is a part of the Schedule A or it is a government land.
Definitely.
And then that can be easily would have been done by appointing Amin Commission.
Now, whichever method they use. Say the example I gave, you claim your right
that you are the owner of a red pencil. He claims I'm the owner of a blue pencil. And I don't know what I'm deciding. I'm deciding regarding a blue pencil or deciding regarding a red pencil. I don't
That is happening.
So what will I decide? It is admitted you are the owner of red one. It is admitted he is the owner of blue one. So if I don't know which pencil I am deciding and what is the color, in whose favor I will give the judgment? It's a common sense logic, nothing. Yes, young madam, one sitting on the right. Yesterday she was very concerned when I refused the judgment.
She is my daughter-in-law.
The daughter-in-law.
Sorry. Granddaughter.
Granddaughter.
My son.
Okay. She was very concerned when I refused the adjournment.
Yes. This year she joined.
Cool. Any idea whether he'll be available tomorrow?
Tomorrow I think he will be available.
Can you inquire from Mr. Ali whether he'll be available tomorrow?
We'll try.
Please try. Then I fix it tomorrow, day after tomorrow, and deliver the judgment. Hearing is over. No more hearing. Only thing, after you have produced the judgment, if he wants to say something, I should give him that opportunity. Thank you. Tuesday. Not tomorrow. Tomorrow the reference will be there. Second. Tuesday.
It's for the convenience of
List on Tuesday. And in the meantime, ask Mr. Ali to at least to remain present.
Okay. Obliged.
Thank you.
Time being 25 and 26.
Your Lordship, there was order 21, rule 44, Your Lordship.
No, why did I adjourn timely?
Because of the how to attach the.
Right.
Your Lordship may kindly peruse provision contained in order 21, rule 44.
21?
Order 21, rule 44. Your Lordship may kindly the query that Your Lordship had raised here. And 45 is the other part.
This is RSA.
Yes. Because the degree of
you are for the
I'm for the
plaintiff and respondent in the RSA. It's a concurrent judgment.
Concurrent finding in my favor and there was a permanent
And who
injunction
appears
in
for
our.
the appellant? Who appears for the appellant? Appellant, who appears?
Appellant Mr. Shom is there.
Oh.
Yeah. Shom and Chauhan, both of them.
S. Chauhan.
S. Chauhan, and I think in the last order it is Mr. Shom is reflected.
Mr. Chauhan was there. In one of the earlier orders, I have seen
Mr. Chauhan was there in the order which I have filed for saying that the violation has taken place. Mr. A.R. Shom's name is.
N. Sarkar, S. Borgohain, they are with you. They are with you. Then it will be S. Chauhan and A.R. Shom.
They have filed their objection. They admit to that they are carrying out, they are only cultivating.
Yes, Chauhan, R.S. Chauhan, yes. Mr. Biswas, in the second appeal, is there any interim order?
The interim order was granted on 25/5/22.
What kind of interim order?
While admitting the judgment and decree was stayed, Your Lordship.
Judgment and decrees stay.
This is reflected in this particular order which I have.
By
annexed
which
along
order
with
it
my
was stayed?
application, Your Lordship.
Regular second appeal is admitted on the following question of law. Appellant liberty, issue notice, take steps, list after 6 weeks. Where is the stay?
So that is reflected in this order of 9/6/23.
9/6/23.
That's in your
9/6/23
lordship.
in which case? How many second appeals are there?
There are two second appeals. One is in the against the counterclaim. That is a different, against the, this is the against the counterclaim. And the other one is against the main suit.
Main suit.
They have filed two separate.
So RSA 58 and 60.
58 is with regard to the counterclaim.
This is 58 regarding counterclaim.
Your lordship,
Counterclaim
that it was,
No. Just a minute. Counterclaim is by them.
that was also rejected.
But where is the interim order?
Your lordship, there is another IA civil 1095. Your lordship.
1095 is also there. Huh? It is in RSA 58.
1095. Here, your lordship may tell 9/6/23 order. Your Lord. There is a reflection that on 22nd para it is stated that on 25.
On 25/5/2022. Heard shown this thing. Where is that interim order?
That is, I could gather from here only.
No. This order is passed in a IA in RSA 58.
Yes, sir.
Okay. Order is on 25/5/2022, this court, while admitting the regular second appeal, directed the decree so and so shall remain stayed till the disposal of the appeal.
Yes, that is the.
Very well. This is on 9/6/2023. So we have to refer to order dated 25/5/2022 in RSA 58. This is the order. Can you notice any state? Just
I
check.
I also checked the record, your lordship, it is not there.
Then we'll clarify this order. That's
Yes.
all. That there is no state.
Means, this order shows there is a stay, but
No.
from the
Stay
record itself,
order
it is.
cannot be by implication or by showing. Stay order
There
has
should
to
have
be,
been some
there has to be a stay order.
subject to further correction, your lordship, but I could not trace out from this record.
Then there is no stay order. We'll clarify this 9/6 order.
This is
No,
another
after
IA.
hearing both sides opinion that till disposal, nature and character also.
Lordship, there is another IMI, we are saying. 1109, I think that is a stay application.
1109.
Yeah, I think that should be.
I think that remains state.
But that is not reflected in the main. order.
Court must have wrongly recorded.
Yes, sir.
25, that is the page in I stay is there. So what is your application now?
My application, your lordship, that
To vacate the stay order.
not vacate, your lordship, attachment of the agriculture means attachment under order 21 or 39 rule 2A.
And the original claim of the plaintiff is that this is.
All the relief your lordship will find in the RSA.
No. So what is the original claim in the
Yes.
plaint?
For eviction, right title and interest,
And eviction,
eviction and permanent injunction.
permanent injunction. And what is their claim?
Their claim is they are in possession on basis of some sale deeds, etc. Counterclaim,
Sale deed means they also claim right title and interest
yes,
on the basis of a sale deed. Your sale deed pertains to which land?
the same land,
And their sale deed?
the same property.
Same plot of land, there are two sale deeds.
On the counter claim, yes.
Whatever it is, on the same plot of land, there are two sale deeds. One they claim and one you claim your right. Which one is prior in time?
Prior in time, our case, because
No. Which of the two sale deeds are prior in time?
ours,
Yours.
the alleged executant of the sale deed was also examined by the learned trial court. She did
Mr.
not.
Biswas, this is the difficulty with the civil
Yeah, understand
lawyers.
that.
Civil lawyers know how to complicate matters, and we are trying to simplify the matter as far as possible. Even I've noticed in the civil courts, everybody tries to complicate the matter. And in the endeavor to complicate it, you lose track of what is originally being matter about.
The various miscases for the complication.
So, you have two judgments in your favor, accepting the prior sale deed. And their counterclaim was rejected.
Yes.
And both are reasoned order.
Yes.
Both are reasoned orders. And now, what is the substantial question of law?
We have shown them,
Whether the plaintiff successfully discharged, whether the defendant successfully proved, whether the objection, these are nothing.
These are general.
These are not substantial.
This is not touching upon the substantial, it is a general.
These are not even question of law.
You respect, that would be my argument when the matter comes up, because.
Ask Mr. Shom to remain present, we'll ask him to reframe the substantial questions of law. And if we can make out, we'll think of some interim order. If we cannot make out, we'll continue without an interim order.
On 10th, because we have to inform him, today is 8th.
Sorry?
No, next week. Then next.
Eighth? That's what you call it.
That was not. Next week.
I heard Mr. E. Biswas, learn counsel for the applicant in. Now, which I?
IS.
There are hundreds of I. In I 2546 2023. 2546. RSA 58 2022 had been instituted, being agreed by the judgment and degree dated 23/12/2021 of the learned district judge Udalguri in title appeal 01/2019, as well as the judgment and decree dated 10/4/2019 of the civil judge Udalguri in title suit 03/2014, where by concurrent judgments, the suit as well as the appeal of the present, by suit as well as the appeal of the present appellants, not suit, suit of the present applicant respondent in the second appeal had been allowed.
Yes.
Allowed. And the counterclaim of the appellant defendants had been dismissed. The applicant respondent claims right title and interest over the suit land by relying upon a sale deed dated
What if it is stated here in the plaint, it has been mentioned about it.
give the date, whereas the appellant defendants also claim right title and interest over the suit land by claiming their titles under a sale deed dated so and so. it is noticed that both the sale deeds pertain to the same plot of land, which is in fact the suit land. The RSA 6020, the RSA 58/2022 which is against the judgment and decree dismissing the counterclaim or allowing the suit.
It was
RSA
rejecting the
58
counterclaim and allowing it is
RSA 58 is
RSA 58 against the counterclaim.
yeah, keep on.
Against the judgment and
Decree by which the counterclaim was dismissed. Whereas RSA 60/2022 is against a part of the judgment degree by which the suit of the respondent plaintiff was allowed. While admitting the two appeals by the order dated 25/5/2022, the following substantial questions of law were framed. Based upon the admission of the two appeals by the orders dated 25/5/2022, upon the aforesaid questions of law being framed, there is also an order dated 25/5/2022 in ISC 1109/2022 in RSA 58/2022, staying the judgment and decree dated, appellate judgment decree dated 23/12/2021 and the original judgment and decree dated 10/4/2019. In the circumstance, IA 2546/2023 has been instituted by the respondent plaintiff for attachment.
For the violation of the intimating this and for under attachment and
No,
punishment.
there is no
under-
violation. Judgments are stayed. There is
means,
no provision anywhere.
Direction has been violated.
Which direction?
The direction of this honorable court.
Which direction?
That hearing both sides, order dated 9/6/23. In
where is that order?
1095.
9/5.
Because after the stay order
You
was
need
granted-
one assistant to find out your number of petitions first. You have to pay some extra to the High Court. High Court will employ one person to find out.
We have filed two applications.
Pay double the court fee to bear the cost of the. Now, which one?
1095.
1095. Okay, 1095.
Yes, then order dated 9/6. Oh, yes, yeah. Mr. Shom is.
Appellant opposite party, who is the appellant or has been trying to change the nature. Today, Mr. Sarkar submits. For whom does Sarkar appear?
Sarkar, he is the.
Who is Sarkar? You are Sarkar. So you are with Mr. Biswas. Submits that the appellant over has been trying to change the nature and character. And it shall not be changed. Very well. People look.
Based upon the admission of the appeals.
The order was passed.
On the opposite version of law being framed, there is also an order dated 25/22 in.
To stay. In the aforesaid circumstance, IS Civil 1095/2023 was instituted by the apparent defendants, raising an issue that taking advantage of the stay order of the two judgments, the respondent defendant applicants are trying to change the nature and character of the suit land. And accordingly, an order dated 9/6/2023 was passed in IS Civil 1095/2023, providing that till the disposal of the appeal, the nature and character of the suit land shall not be changed by any of the parties. But in the it is the assertion in IS Civil 2546/2023 that in violation of the order requiring restraining not to change the nature and character of suit land, the appellant defendants are continuing with cultivation activities over the suit land. And therefore, according to the applicant, it is a violation of the order to retain, to not to change the nature and character. In their affidavit filed in IS Civil 2596/2546/2023, which paragraph, Mr.
Para
Biswas?
13, para 14, your lordship.
14. In paragraph 14 thereof,
Second part of the second para, it is a fact.
the appellant defendant states that it is a fact that they are cultivating the land as because there is no prohibitory injunction in respect of the land. And therefore, there is no violation of the order dated 9/6/2023. In other words, it is the stand of the appellant defendants that carrying out agricultural activities and changing the nature and character of a suit land are two different aspects. And therefore, they are entitled to carry with the agricultural activities. Next paragraph. If we look at the core issue between the parties, it is the claim of the respondent plaintiffs of right title and interest over the suit land based upon a sale deed.
As well as inheritance.
Based upon a sale deed dated so and so, as well as inheritance. Whereas it is the claim of the apparent defendants of right title and interest over the same plot of land based upon another sale deed dated. You have to give us the date. We have already kept it blank. Dated so and so. Apparently, the sale deed relied upon by the plaintiff respondents appears to be prior in time than the sale deed relied upon by the apparent defendants. But the apparent defendants have raised a substantial question of law, whether the sale deed relied upon by the respondent plaintiffs had been proved under Section 65C of the Indian Evidence Act. As the issue as regards entitlement of the appellant defendants to continue with the agricultural activity has a direct bearing with the substantial question of law raised. That is, whether the sale deed relied upon by the plaintiff respondents had been proved under Section 65C. We propose to examine the said substantial question of law. Yes, Mr. Shom, argue now. We want to examine your substantial question of law.
Lordship, actually, my senior, Mr. H. Chauhan, was.
That doesn't matter. For us, every learned counsel is a learned counsel. when we write the expression,
Lordship.
we use the word learned across the board in respect of all the council. So everybody is learned for us. We never say, right, learned council Mr. S. Chauhan and non-learned council Mr. A. Shom. We never write like that.
That is right.
All are equally learned. So you please submit. Firstly, you tell me the sale deed relied upon by the plaintiff, is it a registered document, it's a certified copy, or it is a plain copy?
Lordship, because my senior.
No, we have heard you. I heard about your senior. Mr. Biswas.
Yes.
The sale deed relied upon the plaintiff.
That was the origin.
It's a registered
Registered
document.
was to be.
Registered document. Or it is a certified copy.
No, it was the registered.
Registered document.
Yeah, case.
If it is a registered document, is section 60, section 65C of the Evidence Act applicable?
In case of registered document,
we have
in
been-
case of original registered
We have
document.
been told that the sale deed relied upon by the plaintiff respondents, which is exhibited as exhibit.
In the judgment, it has been decided.
Is it exhibit A?
Yes, it's. Exhibit is sale deed.
Exhibit A.
5.
A5.
Exhibit, it has been marked as exhibit 5.
Not A.
No, that is. Defendants, they have marked as A.
Sorry. Same sale deed.
If your lordship comes to the
Mr. Biswas.
memorandum of,
Your sale deed,
no,
is-
not the same sale deed.
your sale deed is which exhibit?
My case is based upon exhibit number 5.
Keep on.
Yes.
Is exhibit 5.
Yes, sir.
And who relies upon exhibit A?
Exhibit A is
Defendant.
defendant.
And on the
A
other hand, exhibit A is a sale deed relied upon by the
A and B
appellant
are
respondents. So if you have not proved your own case, what substantial question of law you have framed in your favor? You are doubting your own deed.
Lord,
Mr. Shom,
Lordship.
he relies upon a sale deed exhibit 5.
Yes.
If the facts are correctly given to me.
Yes.
You rely on an exhibit sale deed which is exhibit A. Now read the question of law, friend. You are doubting your own exhibit. So Bishop, please try to explain him, but possibly he came in between him and not. Subsequent question now is in order dated 25/5/2022 in RSA 58. It will DD, okay? It will DD one. Look at this order.
Lordship.
Read the question number 2. Something went wrong, Mr. Shom. You are doubting your own document.
They exhibited the certified copy.
Whatever it is, they doubt their own document.
The question of law is.
You should have challenged their document, not your own document.
Question number 1 in respect to.
No, so we'll decide that question, no difficulty. But you are challenging, by this ground, you are challenging your own document.
Lordship, because that was not accepted by the trial court. So,
Your document.
yes, your Lordship. So
we'll decide it.
probably
But
this question of law. Because
Take us to the judgment where it was not accepted. Which line of the?
because our document was certified copy, Lordship, same thing. And plaintiff.
Show us where the
Lordship,
trial court has not
Lordship.
accepted it. Show us in which paragraph of the impugned judgment.
Yes, Lordship.
This, your sale deed was not accepted.
Para 37 of the,
37.
first of the trial court judgment.
Page number.
Para 37, it would be internal page
No,
17.
Internal, I difficult to find out.
In
I found the
the
external page.
memo of appeal, 77, I
Page
think.
number. I have found out the judgment of the whose judgment is the signature verification. These are all some
36, they have relied upon the judgment. Of the memo of appeal.
I don't have the privilege of holding a copy like Mr. Biswas. And if you say page number from your copy.
It is
how
page
can I find out
77, 77 of the memo of appeal.
At least 10 different readings before me. How can I find out the page number? Page number, how much of memo of appeal?
Memo of appeal, page 77.
77, of which RSA?
This is 58.
58, 77.
This is with regard to issue number, your lordship will find.
No, whatever it is, where is the conclusion that
Lordship, page 78, para 39.
39?
But in the suit in hand, the plaintiffs have all along objected in admitting the certified copies in absence of laying proper foundation for not exhibiting the original sale deed. And such raising of objection is evident from the cross-examination of the witnesses.
So this is a
of the
very pertinent ground they have raised. Certified copies are governed by which section of the evidence?
65.
Are you sure?
Yes.
64, 64.
That is certified copy.
Are you
That part
sure?
is there.
Means 65. They wanted to lead a secondary evidence on 265.
Mr. Biswas, they need not. Look at section 76.
That is
76, Evidence Act.
Public documents. Yes.
That's a provision for a certified copy. Then reads section 79.
Genuineness of a certified.
It need not be proved under 65.
They have to, means as per there are judgments, if I may be permitted. Was sale date, etc. are not public document per se. And initially they have to bring it, if at all it is not there, then the registrar has to be brought in to verify that.
But certified sale deeds are not public documents. Why not?
Lordship, may I?
Public documents following are public documents following act or records of acts of public public records kept in any state or private documents. Sale deed is a private document.
Yes.
But if it is kept in the public record, it is a public document.
That is true.
So once it is a public document, section 76 will be applicable and its genuineness flows from section 79.
And
so there is no requirement to prove it again.
for due respect, Your Lordship, the registrar has to be examined. That is the.
Why?
To prove that this was.
Under which provision of law?
That the.
65. What is 65? Let us read.
Because.
No. Let us read 65. Secondary evidence may be given of the existence or condition or contents of when the original has been destroyed or lost, when the party offering evidence of its content cannot for any other reason not arising of its default neglect produce it in a reasonable time. So suppose today I have a say promissory note. Mr. Biswas gives a promissory note to Mr. Sean that you'll give him 10,000 rupees. That promissory note is not found original. Section 65 will be applicable. Okay. But when it is a certified copy of a public document, 65 is not applicable. This is the havoc being created by all civil courts. I'm aware of it.
Now,
this morning I have delivered a judgment.
No, it's
Intend to deliver in case of Mr. S.P. Roy's case.
79 says duly certified by any officer. So for that purpose, that the signature.
You could have challenged it saying that it is not a certified copy. You always have the option. But you cannot say 65C will be applicable.
Because they led the evidence through 65, means they filed the application.
The moment a certified copy is filed and accepted and exhibited, 76, 76 and 79 will come into play.
But
Mr.
Understand your logic.
This was today I deliver a judgment.
Yes, I was there.
Do you take my originally signed judgment somewhere else? Never. You take a certified copy. Now, if this certified copy has to be proved under section 65C, the Registrar General will be busy in every court in the whole of the state of Assam, proving that this is a certified copy and contents issued by the High Court. Registrar has to be withdrawn from all other duties.
No, your High Court is totally.
No, there is no difference.
Body,
there is no difference between a public document, whether it is High Court or it is Sub-Register Court or it is any.
The Apex Court has held time and again that sale deeds, certified copy of sale deed cannot be a prima facie.
Let us see one of those.
Today I have not carried it. Lordship fixes it. I can place the report. There is certified copy of a sale deed. Means there are judgments there with regard to that.
A certified copy of a sale deed available in public record or unavailable in public record?
I think that was also a public record because certified copy registered.
Okay.
If your lordship just permit me, if a date may be fixed, I can place it. I'll just place it on this point.
Third in part is concerned. So,
yes.
Mr. A. Biswas, plain counsel for the respondent plaintiff seeks for an adjournment to produce the relevant proposition of law that even a certified copy of a sale deed has to be examined under section 65C of the Evidence Act.
And as your lordship said, 79 presumption would not be.
And that's right, under 60.
Yes.
Maybe
I'll try to.
Maybe possible. I don't say you are wrong.
No, I'm not saying your lordship is. This point is there, your lordship.
And if it is decided, we'll definitely follow it.
I'll just try
but we'd like to see it also.
Yes, your lordship.
And any reason given? Why?
That is there. That has to be.
And now, who will be examined? Just tell me.
Interestingly.
No, just tell me one thing. Who will be examined?
The executant of the sale deed itself.
Executant of the sale deed. Suppose,
she was examined, your lord.
Mr. Suppose, forget about in this case. Suppose my father had purchased the land 70 years back. A dispute arises, I rely on that sale deed. I will have only a certified copy of the sale deed with me. Okay. Now, can I bring back my dead father to give evidence?
that it is he who had executed his LD now come and give
30 years
evidence.
period, that
30 years document.
30 years law.
Doesn't matter. Suppose my deed was executed 2 years back, my father died about 1 year back.
There is a gray area of the civil law.
It is difficult. Therefore, Evidence Act has also brought in 76 and 79.
There is some gray areas which overlap some parts.
We don't know. Maybe Supreme Court is per inquirium also. We'll have to check out. If it is per inquirium, we will not follow it.
I'll just try to satisfy your lordship.
Suppose this is the law, how do you expect me to prove my sin deed now? One example I am giving. In 2017, my father purchased a plot of land. In 2019, he died. In 2023, somebody is trying to take away my land.
I have to produce that.
I filed. Now, if he insists Section 65, how will I prove it?
Means then the record from the registrar has
This
to be
is
called.
exactly. Records from the
Registrar has to be
register.
called.
Now there is a Supreme Court judgment that if it's a registered document, there is a presumption of its validity.
That is 79.
There's a
Means that presumption, due respect to your lordship, might come after the registrar says that the original record is not registered.
No. Supreme Court has unequivocally said that whenever a registered document is produced, there is a presumption of its validity.
Until and unless I challenge.
Until and unless it is challenged by the other side, and the burden is on the other side too.
That is not correct.
So
That
now,
is pleaded in the WSC. your lordship.
no, then the burden is on you, not to him. The reason for rejecting his thing that he could not prove 165 is not a burden, his burden. It is your burden. If you want, we'll allow you to prove it.
That can be, I mean, subject to my submitting that, your lordship, the remand back can be done, but let me give me a.
No. Now I can't decide this agriculture issue.
Yes. No, once there is this point is there, your lordship, that has to be decided for final agreement. So the date may be given so that I can place that. Any date, your lordship.
15 November.
Okay.
Because that proposition will be little dangerous, 65
Yes,
seat.
that would
If we
carry
have to
forward
prove.
in the other.
So we'll have to look Supreme Court. If it at all it is stated, under what circumstance it was.
It cannot be in a, he has to read in the whole manner.
Otherwise, everybody will be compelled to bring back their dead father. Or else, moment I come to know somebody has lost his father, I'll go and occupy his land. Because you cannot prove.
Yes.
Because you can't bring your father to discharge the burden under 65C. So it will be good opportunity for the land mafia.
I'll try to
Find out who has lost his father. That's all.
That is true, your lordship. That
The law can't
obviously
be, can't be
will
so,
come, yes.
can't be so loose.
The hiccups come with regard to that. I'll try to satisfy.
Let us see what is the most correct.
On
decision.
15th, I will take this.
I'm sorry for lordship, I'm sorry. I was in another court, so earlier that was already left over, now it is again.
Are we aware of Order 17, Rule 6?
Lordship.
C. Order 17, Rule 6C. Are we aware of?
Escape lordship.
Sorry?
A senior inspector.
No. Have you noticed Order 17, Rule 6C? No.
Sorry for that, lord.
No, you need not be sorry. Please read that provision. Next to you.
Timing 36.
Obliged.
You are appearing?
For respondent number 1.
What is the IA for, Mr. Mahmood?
For injunction matter.
Injunction.
In the pendency of this appeal, the respondents, opposite parties are trying to sell the land and also trying to erect the boundary walls. So, my lord, in the.
Is there any stay order in the appeal? No.
No.
Appeal preferred by your client.
Yeah. In the first trial court, we got decree and that was reversed.
No, the RSA had been admitted.
RSA has been admitted.
And no, is there a stay order?
No, there is no stay order.
Then they have the liberty to do anything.
That's why you have filed injunction petition. That is why you have filed injunction petition. And this case is pending.
Take instructions from the client. So,
I heard Mr. M. U. Mahmood, land council applicant, also heard your name, please.
Mr. D. Bora, appearing for Mr. P. Pradip.
Don't say so many D. What is your
Mr.
name?
D. Bora.
You are Mr. D. Bora.
D. Bora.
You look it up. And Mr. D. Bora for the
Respondent number 1.
for respondent number 1. On an allegation that even after admission of the appeal, although there is no stay order, the respondents taking advantage is trying to
Erect the boundary work and
is
also
trying
alienate
to,
the land.
trying to alienate the disputed land as well as construct certain boundary work. Mr. D. Bora, land council respondent, seeks for an adjournment to, for what you want to obtain some information from whom?
And will file a reply.
Seeks for an adjournment to file an objection. Pray aloud till the next returnable date, a status quo as regards the disputed land be maintained. Notice not issued, no? Issue notice returnable.
I think 2 weeks.
Returnable 4 weeks.
Somebody.
449.
The reply may be submitted within the returnable date. Okay, extra copies.
Notice is not 4/4/2019.
Which notice? This I?
Not I.
No, I is of 2023. We are issuing notice in I.
Copies already start up on my 11th page.
Give him one more if he wants.
Received on 4th of October.
Thank you.